Good afternoon. Welcome to SERMAPod. My name is Brian Rosenblatt. I am the general counsel and a advisory board member for SERMA. And with me today is our special guest, Aaron Moss. Aaron is a partner at MSK, Mitchell Silverberg and Knupp, formerly, in the entertainment, intellectual property, and litigation practice groups, where he represents owners and users of creative content and copyright, trademark, right of publicity, idea submission, and contractual disputes. Aaron, thank you very much for joining us today.
Hi, Brian. Good to be here.
Good. We're going to talk about an interesting case that was filed this past month, but it's got longstanding and much deeper ramifications, and I think that it's something that our listeners are going to find very, very, very interesting. Um, just Desserts, Crumbl, the dessert and cookie company based out of Utah, was recently sued by Warner Music Group over alleged unauthorized use of music by artists such as Taylor Swift, Lizzo, Beyonce, and others in its TikTok posts. Um, Warner Music Group, including companies like Atlantic Records and Bad Boy Records, amongst others, filed this lawsuit against the Utah-based Crumbl, claiming that the dessert chain repeatedly used its artists' music without permission in social media ads over several years. Um, it's alleged that Crumbl used at least 159 sound recordings, that they had been put on notice of copyright violations, that they continued to do so. And Warner Music Group and the plaintiffs are looking for $150,000 per work infringed, or nearly $24 million. That is what we are going to be talking about, not necessarily specifically just to this lawsuit, but the overall ramifications and really what we're talking about here. Um, let me just start with this. On a broad scope, Aaron, tell us why this lawsuit is filed. What is really at issue here?
Well, we've seen this more and more recently, where music companies, both record labels and publishers, have filed lawsuits against brands that have been using their copyrighted music in advertising without permission. And it really comes down to the fact that these are ultimately like commercials for the products. So they may be on social media, they may be done by influencers, but the allegations are that they serve an advertising purpose. They're commercially used. Uh, uh, they use the songs in a commercial use without paying the appropriate licenses that would be required if it were on a TV commercial, for example. And so we've seen over the past few years there was a huge lawsuit against the company behind Bang Energy, a multi-million dollar lawsuit there. We've seen earlier this year lawsuits filed against Marriott and the owner of the Chili's restaurant chain, and a number of others that have been using copyrighted music in their social media posts.
So when we talk about copyrighted music, because that's really at issue here, um, what are the different copyrights that are involved?
Right. So you typically have two copyrights that are involved in any use of a given song. So there's the copyright in the underlying musical composition, and then there's the copyright in the particular recording of that composition. And those two copyrights can be owned by different companies. Here, in fact, they are owned by different companies. They just happen to be all under the Warner umbrella. So Warner has its publishing arm, Warner Chappell, and some other affiliates, and then they have their record labels, and a number of these labels that own the sound recordings are also joined in this lawsuit. But the important thing to understand is that anytime you use a piece of recorded music, there are two copyrights. So even if, for example, you have permission to use a composition from the owner of the underlying music, or if, for example, the music's in the public domain, if there's a particular recording of that song, either a licensed song or one that you get from the public domain, if you don't have permission to use that recording, that embodiment of the composition, then you could be liable for infringement. Now, here, the allegation is that Crumbl, in using popular sound recordings, did not have either a sync license, the right to use the underlying composition and synchronization with video, and it did not have a master use license, which is the right to use the sound recording. And therefore, with respect to each one of these infringing videos, the allegation is that Crumbl violated two separate copyrights.
Okay, so just just want to make sure that that we're clear when we're talking about the master use license. That that is permission to use the copyright in the actual recording. Is that fair? Okay. And when
Correct.
we talk about a synchronization license, that is permission to synchronize the composition, the song, the melody, the lyrics that was recorded, to synchronize that with a video element or a visual element.
Correct.
Okay.
Correct.
And traditionally, yeah, you need both in order to be able to use a piece of recorded music in film, television, advertising. This really, the fact that it's on TikTok or social media should be no different. Is that is that fair?
Right. I mean, that's certainly the allegation. I mean, I think that there has been uh, I don't know if you call it an old wives' tale, this urban myth that somehow because it's on social media that a different set of rules applies. That's not true. There is no internet exception to copyright law. There are certain instances in which um, use, by an individual in connection with social media is likely, not going to be infringing if it really is just for personal use. Somebody does a video with a dance in their living room and uses copyrighted music in connection with that. And nowadays, most of the platforms, including TikTok, do have licenses. They have libraries of commercial music, but the terms of service for those social media platforms provide that that's only for personal non-commercial use, not for using the copyrighted music in connection with advertising for particular product or service. And so that's where I think that there's some confusion out there, obviously, still, because these lawsuits are still being filed about the need to get licenses on social media. But I think brands are starting to learn pretty quickly as a result of the recent filings that, in fact, they do.
So let me ask you this because I've been practicing entertainment law for 28 years, and I've had the good fortune of litigating alongside of and co-counseling with a few of your partners and a couple of your former partners in some pretty hefty cases over the years. Um, what we're talking about here doesn't strike me as anything new. This strikes me as exactly what I learned in law school. So where's the disconnect, or how does a brand have the audacity to think that they get away with essentially taking something that's not theirs?
Yeah, I obviously can't look into what the motives are in this particular case with regard to Crumbl. I mean, there's certainly allegations of willful infringement, allegations that Warner Music sent cease and desist letters to the company, that those warnings made their way to the social media folks because they even reference tongue in cheek, legal says not to use trending audio. So not only um, acknowledging receipt of those cease and desist letters, but kind of brushing them off in attempted humorous way. But as for why and how it happens, I think it's typically a function of the fact that social media, most companies tend to have more junior um, folks on their team, people that are very internet savvy, um, very marketing savvy, really know how to amplify the reach of content on platforms. But if they have not been trained in law, which many of them haven't, these are, you know, as I said, not always, but typically um, people starting out in their career. Maybe they have had some training, but often not, and they just don't understand what the law is. And of course, when you look on social media, you see every day memes being shared and songs are on the various platforms, and I think it leads to a belief that is probably pretty pervasive if you were to do a poll of of younger folks on the internet as to whether or not you need permission for these commercial uses. I think that this is something that could be fixed if brands would have lawyers give training to their social media teams. I've done that in the past for clients where, kind of given the rules of the road in terms of what you can do, what you can't do, how not to become the target of one of these suits. And I think what's really surprising here, you would expect this out of you know, Joe's Cookie Shop, that has, one location in Hoboken and is operating on a shoestring.
Sure.
Crumbl, of course, has, 1,000 or more locations, and I read at one point, was seeking a valuation of like $2 billion. So it's obviously a big company, and it relies on influencers and has a social media team, of probably two dozen or more people. So it is surprising that a company of this size and with this much success um, would have been caught doing this, or would have done it in the first place. But that certainly appears to be the
Well,
case.
let me ask you this, because you mentioned there may be more youthful individuals helping with the program. They may be more social media savvy. Um, we have younger associates at our firm that we train and oversee that don't necessarily have the same legal experience as a senior partner would, and I know the same thing applies at your firm as well. Um, at a certain point, isn't there somebody above these individuals that has to condone what they're doing? And I guess is it a matter of it's just easier to ask forgiveness than to seek permission, or is it a matter of there's no impetus, there's no incentive to stop or avoid this until somebody makes an example of them with a large money judgment?
Yeah, again, I can't speak to what happened here. Certainly, if you were a social media manager, or in-house lawyer at one of these companies that does a lot of social media advertising and may use popular music in connection with that advertising, you would have heard about, the Bang Energy case as an example is one that really made a lot of headlines 2 or 3 years ago just because of the numbers involved. Um, as did the cases that were filed earlier this year. And so it is still surprising that um, that brands think that they're somehow immune, especially if they're visible and they are, are popular on social media. They're obviously going to be bigger targets. But I would be really curious to know what the thought process here was. Whether they thought that they were covered by the TikTok commercial library. That's sometimes a defense, although here the allegation is interesting that um, the um, the audio files, or the video and audio shows original audio um, as being represented, and the allegation is that's to evade some sort of detection. If this had used in-platform tools, then the artist's name would have showed up on the social media feed. So it looks like this was created offline and potentially then
So
uploaded.
what does that mean? Using it as original audio. What does that mean?
So on these social media platforms, typically you have the choice of selecting music from within the platform using in-app tools. And the tools often provide both um, commercial use songs, which are generally, what we would have called back in the day elevator music, not popular stuff that most companies would actually want to use. And then the the libraries, do offer um, popular music, but those are limited typically by the terms of use, almost always to personal non-commercial use. And so sometimes if you have a personal account, but you are able to use the in-app tools to create a video that uses copyrighted music, there's a way to evade the any in-app restrictions on the ability to do that. Doesn't mean it's legal if you use it for a commercial purpose. But here the allegation is that Crumbl did something different. That if you were to post a video and you were to have your own audio, you were gonna have speaking, or you were going to have external music, that would be recorded by the social media app as original audio. And so it suggests that Crumbl was not using the in-app tools for getting this music, but instead was uploading it offline, claiming for it to be original in the sense of not in platform. But the allegation in the complaint is that by suggesting that it was original, that was an attempt to, um, evade detection as for the use of copyrighted music.
Kind of sounds like that will be used as evidence of intentional infringement, that they knew exactly what they were doing, as a way of trying to deceive or trying to get around. And let me ask you this: what I mean, we read the article. The article says $150,000 per track that's been infringed. $24 million is what the complaint is looking for. How do we break that down? What kind of damages is a company looking at, either recovering or paying in a copyright infringement suit like this? Well, how does that break down?
Yeah. Well, so look, it typically these cases, they almost always settle. And so you'll go into a mediation, or you'll have an unmediated settlement conference where, depending upon the number of songs and the way that they were used, you'll try to come up with a number. I think a lot of it depends on whether there's insurance or not. A lot of it depends on how deep pockets does the defendant have. In many situations, you have companies that really don't have the ability to pay a 10-figure um, award, whether that's over time or not. So rather than force that company into bankruptcy, there may be, a payment plan, there may be a reduced award, a reduced settlement to take into account the financial circumstances of the company. But there's certainly nothing to stop the brand, the music companies from trying to fully enforce their rights. It is not typical that if you went to trial, that you would get the full $150,000, but it's always a risk, and it has happened. And to the extent that they can put on a good case that this was willful infringement, that is always um, something that the plaintiffs can hold over the heads of these brand owners in connection with any settlement. Now, as far as insurance goes, you got to be careful as a plaintiff about how hard you want to push the willfulness angle, because if the company has insurance but is otherwise not deep pocketed, by pushing the willfulness angle, you may talk yourself out of having that claim be covered by the insurance company that would be able to satisfy a settlement. So it really just depends on the circumstances here. I think that Warner's in a pretty good position simply because Crumbl, insurance or no insurance, um, obviously, has a lot of market cap, at least if you read if you believe the article.
So when we talk about $150,000, that's the full value for an intentional infringement for a work. So for any given song that we're talking about, it'd be $150,000 for the composition and $150,000 for the recording. So $300,000 per song. Is that correct?
Yeah, that's correct. And statutory damages is per work, so it's not per infringement. It's not based on the number of times that the video is streamed or anything like that. It's a set amount based on the work. But as we talked about, there are two copyrighted works involved. For each piece of recorded music, there's the sound recording and the underlying composition. And so, to the extent that both are implicated, and both have been used without permission, you're looking at potentially, if you can show willfulness and if you get the maximum award, up to $300,000 per work.
And then per, per,
Per song,
per song, right?
would be
Both sides of
150,000.
it. So and then what what would we expect in terms of attorney's fees?
Well, I mean, I think that
Hopefully
depends
they settle.
on how far this litigates, because how long it litigates. So if you take a look at some of the cases that were filed earlier this year, for example, the Marriott case is somewhat similar, where the allegation is that the Marriott chain and its various um, partner and franchise hotels had social media accounts that used copyrighted music. That case resolved, within a couple months after the lawsuit was filed, really without much that I could see in the way of any actual um, litigation. And so I think companies that get hit with these lawsuits are recognizing that there's not a great defense. I mean, there's fair use in this kind of situation if it's a commercial product and you're using the song. And here the allegation is that not only are you using the song in a commercial product, but you're actually tying back the video to the song itself. So if you have a butter cookie and you're using BTS butter, you're trying to do things that that call that make use of the particular song that's being featured. But as far as attorney's fees go, the good thing about settling early is that you kind of limit the amount of attorney's fees. And typically, if a case is settled, both sides will agree to pay their own attorney's fees. Whereas if the case ends up being litigated and goes to an award, there's discretion that the court has to award attorney's fees in favor of the prevailing party, which, in a case like this, it's hard to see, any substantive defenses um, that a brand that uses music like this, on such a large scale without
Okay.
permission is going to have.
Um, you also mentioned insurance. So generally, we're talking about either an advertising endorsement to a CGL policy, or we're talking about the errors and omissions coverage. Um, when have you seen these claims covered by insurance or not? Is it just the willful issue?
Yeah, I mean, so I think generally there's going to be, what's called a reservation of rights that's issued if there's willfulness alleged that the carrier might provide a defense, but then subject to a determination of whether there's actually coverage at the end of the day. But as for whether the policy would cover it, um, as you noted, CGLs, generally have advertising injury, although some of those policies may specifically have IP exclusions. So you got to check the endorsements and read the policy carefully. Um, the E&O, insurance for media and advertising, that may cover copyright, but typically willful, infringement is going to be excluded. But I always tell clients that are on the receiving end of these kinds of lawsuits, tender right away. Make don't try to, you know, you can have a lawyer that specializes in insurance look at your policy, but if you don't tender right away, you may not be covered, and so it's always best um, to tender. And sometimes I've been surprised when that carriers have agreed to cover claims that I thought were maybe iffy as to whether they were covered by the policy. But you won't know unless you tender to the carrier.
On the plaintiff side, we see this all the time where somebody pleads willful, somebody pleads not quite negligence, but the equivalent of negligence, where it's unintentional. Um, have you seen these types of complaints pled in the alternative, where you've got both the non-intentional and the intentional included, so that it does trigger the insurance, but then also keeps the threat alive that maybe they go excess or they go beyond the insurance for exposure purposes?
Y- Yeah, I mean, well, we got to remember that copyright infringement, the liability is, if some people have likened it to a strict liability. I mean, you would have to show that you own the copyright and that one of the exclusive rights of the copyright owner, here you have reproduction, distribution, public performance, are implicated. Once you show that, harm is in essence presumed. And so the real issue is going to be damages, and there are um, two different routes that a plaintiff can decide to take. So plaintiff can, and plaintiff does not need to elect upfront at the time of a lawsuit whether to go with actual damages and a disgorgement of profits on the one hand, or statutory damages on the other hand. Statutory damages are often um, what is publicized in the press when these cases are filed, because that's where you get the eye-popping numbers of up to 150,000 per willfulness. Willful infringement really only comes into play if a defendant is seeking statutory damages. Now, there may be reason strategically that you would want to introduce evidence of willfulness, even if you were looking to get your actual damages, which would be, value of a reasonable, what a license fee would have been, or profits. Although it's difficult in a case like this to determine to what extent the use of the music was responsible for driving specific profits. But the point about the insurance is that the plaintiff does not need to essentially commit to a theory. You would allege that it's willful, but there's liability regardless. And so, until and unless there's a finding of willfulness, insurance should still be in play. Because obviously, there's a difference between knowing that you're using the music and knowing that it is unlawful to use the music. In situations, and I'm not saying that this is one of them, but if you had a situation where a defendant made use of copyrighted music, say in a documentary, and had a good faith belief that it was a fair use, the fact that that defendant was getting cease and desist letters saying, you're using my music, you can't do that, and the defendant made a determination, no, I think I can, I think it's fair use, I have a good faith belief that it's fair use, even if it turns out to be wrong down the line, that may not support a willfulness claim based on that. So, there is an ability to fight about whether something was actually willful, and I think it's going to depend on the facts as to who was in charge of these accounts, and was there reason to know, was the company being reckless, was the company turning a blind eye. But at the end of the day, when you have a defendant that is not particularly deep pocketed, it's always uh, something to keep in mind as a plaintiff, if there is insurance, that um, you don't want to hard at willfulness that the coverage goes away.
All right. So in the few minutes that we have left, um, lawsuits like this one, you mentioned a couple of others. The Beastie Boys they filed their lawsuits, similar types of situations. Um, you see these cases changing how companies use platforms like TikTok to advertise.
Well, look, at some point there's going to be enough of these lawsuits, and they seem to be increasing. Just this year, there seems to be a pretty big uptick. At some point, there will be a recognition by brands that you can't use copyrighted music for commercial purposes without the appropriate licenses, and so that will lead to one of two things: either social media posts that don't use the music, or they'll get a license. And if you're a company like Crumbl, that is primarily advertising via social media, in other words, you're not spending a lot of money on traditional commercial advertising, then frankly, you should get a license. You should negotiate and get the same kind of license you would get if you were a traditional advertiser on traditional
Gosh, those
commercial
those
media.
sound like best practices. what
Those
what
are best practice. And they're not particularly complicated or controversial, but they're not cheap necessarily, but they're certainly cheaper than a
So,
lawsuit.
what other best practices would you recommend for one on the advertising side, to protect against exposure, to protect against unintentionally using somebody's copyrighted material, or what would you recommend for a company to better protect their own material and better enforce that protection?
Yeah, well, so on the last question, I mean, there are starting to become fingerprinting tools, other tools that you can use to determine whether or not your music has been used um, on the internet. There are ways on certain platforms, if you want to allow your music to stay in videos. I'm thinking of YouTube as an example to claim monetization rights to that. So there are different tools you can use for that. But on the advertising side, it's really important to not only pay attention to what you are posting, what you're creating in the first instance, but also what you are reposting, because a lot of times brands will make use of influencers to help spread the word about their products, and if they are um, if there's evidence that they are encouraging these influencers to create videos um, to promote the products, the influencer may attempt to say, "Well, I'm just using this. This is a personal video, and so I'm using the in-app tools for music." But once the company then reposts that influencer's video on their feed or story, they're now making commercial use of it. And so here, for example, in the Crumbl case, there are allegations of contributory infringement based on the influencer driven posts. So it's important to keep in mind both what you're posting and also what you're reposting, and educating your social media team is very important.
Okay. Well, Aaron, I want to thank you very much. This has been another episode of SERMAPod, and we've been blessed to have Aaron Moss from MSK in California with us today. I want to thank everyone. Keep an ear out for our next podcast, and have a great day. Thank you very much.